And now, it's The Law Show on CL 650. A comprehensive look at everything you need to know about the law. Now, here's Sterling Fox.
Good morning and welcome to The Law Show here on CL 650. Nice to have you with us this Sunday morning. We have our guests from MurphyBattista, LLP, Vancouver personal injury lawyers. Scott Stanley and Stephen Gibson are back with us on The Law Show. Good morning, gentlemen.
Morning.
Morning.
That would be Steve and Scott in that order. Good to have you with us. Tell us a little bit about MurphyBattista. Scott, you've been with the firm for, what, 8 years now?
That's right.
And before joining, you worked for the dark side and came over to the personal injury column. So tell us about that part and why you joined MurphyBattista.
I was Anakin Skywalker for a while. I was good, and then I'm bad, and then I'm good again. So.
All right. So out of law school, you went to work for a big corporate firm.
Yeah, well, it was a firm that did defense work, and there I did plaintiff work and defense work, and I like doing the plaintiff work better, but, the defense work is overwhelming. Mm-hmm. And from there I left to go to a firm that did nothing but defense work and didn't like that, and then I joined MurphyBattista 8 years ago.
And the firm that you were with doing most of the defense work they represented large insurance companies, correct?
Large private insurance companies, yes.
Okay, and Steve, you worked with Scott for one of those firms along the way as well, didn't you?
Yes, our first firm together was McCory Hunter, and we worked there I was there for about 1 year, then went on to a larger defense-oriented law firm. I did a lot of insurance defense.
Right.
Started doing more and more plaintiff work. I actually enjoyed it more, but I started getting into some difficulties with my seniors because ICBC was upset with the fact that I was pushing against ICBC when I was suing them, mm-hmm. but I was also doing defense work for ICBC as well. And basically I reached a point where I said, you know what, I can't do both. And all I started doing was plaintiff's work, and that I only represent injured people now.
That's something that happens in British Columbia. I don't know how many people are even aware of it, Scott, but some lawyers actually work both sides of the street, so to speak, don't they? They represent ICBC and they'll represent plaintiffs on other occasions. If I go to one of those people who does the dual representation, is that lawyer required to tell me that sometimes I don't always work for plaintiffs, sometimes I work for the insurance company? Is that a requirement?
I personally think it is, because a lawyer has a duty of candor and fair dealing with their clients. And I think if you have signed an agreement with ICBC, which most defense lawyers have, saying, look, there are certain remedies we cannot pursue against the insurance company, I think you have to disclose that to your client, your potential client. And some of these remedies are quite, powerful, like alleging bad faith. If you've got a claim that might, go over the available insurance limits, it really limits your ability in some cases to properly and fully represent your client. So I think you would have to disclose that. We don't have to deal with that because we don't do any work for any insurance companies.
Right, exactly. But Steve, I suppose, though, and I'm just on the law show, it's a bit of an education process we have here. So, again, for a person, especially a person who's been injured and now their life has been disrupted, and so now they're looking around for a lawyer. They're looking for some help, for a legal leg to stand on. And where do I go next? What do I do? This is all of a sudden a very new and very large alien world. So as part of the investigating the lawyer process, you need to ask some questions. And I think one of the questions would be, do you work both sides of the street? That's a fair question, isn't it?
It is a very fair question. Most people wouldn't even think to ask that question. You want to know how much experience the lawyer has. Is it a preferred area of their practice to do personal injury? There are many lawyers out there that have, a multifaceted practice where they do wills and estates and a little bit of corporate law and
some real estate conveyancing, a little of this, a little of that.
A jack of all trades.
Sure.
In this area, it is highly complex. You want to have someone who really focuses their attention and all of their attention on personal injury claim, because the law is a labyrinth, and you want to make sure that you do it well if you're going to do anything.
Right. And Scott, another good question for a person to ask of a prospective lawyer is, I would think, do you go to court? And if the person says, and if you're injured enough to think in your mind that, if I have to, this could end up in court. This is serious. And so you would want to ask a lawyer right up front, do you go to court?
Well, I think you do. I mean, if you have a lawyer that hasn't gone to court in 20 years, you know, that would mean that
technically they could say, well, yeah.
They could say, well, what I think that would mean is that the insurance company was correct on all of their files, which I think is highly unlikely, right? But I mean, what we find is everything is electronic now. Like all the cases that we've done are all up in the internet ether somewhere, and they're on our website. And a lot of our clients have already come to us because they know, if they haven't been referred to us directly, those that do search the internet, they see the cases we've done, and we're sort of victims of our own success because a lot of people come to us. They see the big, enormous cases that we've handled, and some people want that same dollar value on their case, and of course every case is different. So yeah, I mean, you definitely want a lawyer that's gone to trial for sure, or has the ability to go to trial.
I would think so. And if a person says, no, it's not what I do, it's not part of my practice, and if you're an injured person who may, Steve, at some point end up in court, then that's probably not the right lawyer match for you, is it?
Well, ICBC, they keep statistics on each and every lawyer that does personal injury work.
I'll bet they do.
And so they know, you know, their negotiation style, they know how often they've been to court, their success rate, and they take that into account when they're negotiating. And if they know that a lawyer is potentially shy about going to court, or, you know, or settle, you know, and capitulate towards the end of cases, they will lean on that lawyer and that client. So if you're dealing with a law firm and lawyers that have consistently gone to court, proven successful, the insurance companies, it's like a check that they will consider that when they're negotiating, that, you know what, we've got to actually pay something that's going to be trial dollars or very close to it.
Exactly. And Scott, I suppose though there's also the matter of money, and these, you were referring to some of these large settlements that you have achieved on behalf of your clients, and so people come into the office going, well, you got a whacking great amount for that person, you should be able to at least get that much for me. Are these enormous settlements, and they do make the papers when they finally come out, are they typical or are they quite rare in BC law?
Well, I mean, I think our firm has done 3 of the top 10 cases in BC. I think we've done, you know, 5 or 6 of the top 10 biggest cases in ICBC, or top 5 or 6 cases in BC history.
Okay.
And so the clients can find those, right?
Oh, sure. It's all up on the internet, right?
It's all up on the internet. We have them on our website so clients can see what we're capable of doing. But losses that large are quite rare, right? And what we want to do when we meet with clients right away, we want to demonstrate that, look, you don't want to have a big claim. You want to have a really, really small claim. You want this to be a complete waste of the lawyer's time, because lawyers do these on a contingency. We do them on a contingency.
Okay.
We want to work with you to see if we can keep your claim as small as we possibly can so that you can get your life back. If you get your life back and you get better, you're going to have a small claim. And let me tell you, my friend, that's what you want to have happen.
And on contingency, Steve, means that if you win, you get a percentage of the award, and if you lose, you strike out.
That's exactly right. It is.
So there's a risk involved with taking on every case, isn't there?
It is it's a business risk, and you know, we understand that when people sign on for a contingency, it's very expensive to hire a lawyer on an hourly rate.
Right,
Sure. It'd be $500 an hour plus, and if you're not getting a result at the end of that, do you really want to spend that kind of money? So if a lawyer does take on a contingency, we're putting a lot of our reputation and our time and effort at risk as well. And the better a client does, the better that we will do as well.
I think with a lot of contingencies, it's not so much that there's a risk the lawyer won't get paid. Say it's a clear example, there's insurance, the other party's at fault. There's little chance the lawyer's not going to receive something, but I think the real risk to the lawyer is that they're going to have to do a long trial. And of course, lawyers make more money settling cases than they do going to trial.
Of course.
But when you sign up, the client gets to pick what happens. The lawyer doesn't or should not be forcing a client to settle their claim. They should be encouraging them to do things that are, you know, logical. And sometimes if there's a lot of money on the table, you really want your clients to take it because that's what's best for them. If there's not enough money on the table, we're sort of agitating for them to go to court. But I think the real risk for lawyers is that you may have to go do a 10, 20, 30-day trial and not make hardly any money. That's the real risk. But that's what you sign up for. And what we see happens is a lot of lawyers that have signed up these clients, when he gets close to trial, they don't want to put that time in, and that's when the clients start to feel the lack of love and, go shopping for other lawyers, lawyers like us.
Right, I was just going to say, in previous conversations on this program, we've found out that a very significant percentage of MurphyBattista's business comes from clients who have not been as well served by their previous lawyers as they imagined they would be in the first place.
It's true. Yeah, you were commenting earlier about the contingency fee and the amount of work that goes into these cases.
Yeah.
I mean, I was involved in one for 11 and a half years. So all those years, I didn't get paid a dime working on these cases, and we spent a lot of money helping, prepare that case along the way. It was a child that had suffered quite a severe brain injury, and she now reached adulthood, and we were able to figure out what the future would look like. You shouldn't be settling when infants, or well, we call them infants, but when children suffer grievous injuries.
This would be anyone under 18,
yeah,
right? Okay.
When children suffer injuries, you have to take the time, and it's years, to see what the ultimate result is with those injuries and how it impacts their education,
right,
their potential livelihood, their ability to live independently. And those things you can't do within a year or two. So many children end up, settling cases long before they should. And, that is something that we shy away from. We don't mind putting in the years. And, working with someone for more than a decade, I think is a testament to show that, we will put in the time to make sure we understand the consequences to that person.
Well, there's an important takeaway already, friends, in this episode of The Law Show. For example, if you have a child injured in a car accident or some other serious circumstances, don't settle. Basically, I'm not you're not putting words in my mouth at all, are you, Steve? If you have an injured child who is traumatically and severely injured, don't settle with an insurance company until that child reaches the age of majority, correct?
It cannot legally settle until the age of 19. But, very often
they'll try to settle.
They try to agree on a number with ICBC, and then they just wait until that child turns 19, and then it's done.
And then the check is done on the birthday, and away you go.
Exactly.
Right.
But we've seen so many cases where that has just really been a diabolical mess because that child wasn't properly evaluated during those years during their injury.
So let me amend that, Scott, to say that a child, the case of a child versus an adult, they're just two completely different entities. And if a child in your life is injured, just don't treat that as you would treat the injury to yourself.
I think our general advice would be, you actually can settle a child's claim before the age of 19. It just requires court approval and public guardian comments.
Okay.
So you can do it. But our general advice is wait and see. They have until they're 21 to file a lawsuit, unless it's a Part 7 claim or an accident benefit claim. They've got to do that 2 years from the accident. But you've got this long period of time where you can see what the consequences of the injuries are. If it's a serious injury like a brain injury, you never know. Like Joe Murphy and Kevin Gorley of our office ran a trial a few weeks ago where really nice kid had a brain injury, did very, very well in school, but it was really unclear how well he was going to do when he got into his professional occupation. You just don't know.
Right.
And
right.
it's more time is your friend when you're dealing with infant cases.
Quick question before we take the break to you, Steve, on this matter of the contingency. Who determines what percentage the lawyer gets in an award? Is this the Law Society or the Attorney General? Is it a fixed number or is it negotiable?
Yeah, they're very good questions. Well, the maximum in a personal injury claim involving motor vehicle claims is 33%. In British Columbia. For non-motor vehicle claims, I believe the contingency is as high as 40% as a maximum.
Okay.
Now, very often you can negotiate off those numbers, and I mean, we commonly do work out contingency arrangements.
But those are the ceilings established.
Those are the ceilings.
Okay.
We can do less, and very often you can get structured percentages that change over time depending on how far into the legal process you go. get more the more work that's done.
If I wanted to learn more about contingency and how that works, would the Law Society of BC have it on their website, Scott? Would that be a good place to go and learn just the basics of how that works?
I think they do. I mean, we actually, for our clients, we actually have the Law Society guidelines built into our fee agreement, so the clients know. But I think someone shopping around for information. The Law Society is a wealth of knowledge. LSBC.com, I think the website is. Or just search Law Society of BC, and you can find a lot of helpful information about lawyers there. You can actually check your lawyers to see if they've been disciplined. Well, again, part of the investigation process, Steve, and those good questions to ask. Do a little homework on the internet, too. That could go a long way towards peace of mind, couldn't it?
It is.
Our guests this week on The Law Show, Scott Stanley and Stephen Gibson from MurphyBattista, LLP, Vancouver personal injury lawyers located in our city downtown at 650 West Georgia Street and online at MurphyBattista.com. We're back with lots more after this.
There's more of the show still ahead. This is The Law Show on CL 650.